Nancy is an attorney and a librarian. She's copyright program librarian at the University of Minnesota. She's going to be providing a bit of a background on some of the legal issues that are at play in here that we need to be aware of as we talk about sharing digital content. So I'm going to stop sharing my slides. Nancy, you can draw up your slides and you're set to go.
Thank you very much. I'm going to just take a moment to get my slides open and then we'll be ready to go.
No worries.
How's that looking? People seeing my slides there?
Yep, we can see your slides. You're all set.
Thank you very much. Thank you very much to NISO for hosting this event and for inviting me to speak. Just as a little tip, I'm going to start with a question for the audience. So those of you who are here to listen, feel free to get ready to type in the chat. Just as a additional hi, here's how you can get a hold of me. I answer email. I'm pretty heavily involved on Twitter, although that's not all copyright related. And I welcome any pronouns you choose to use. Let me see my next slide. So my plan for where I'm going today is to talk very briefly on all of these topics because this is not the longest time slot ever. Talk briefly about the current state of the landscape with respect to copyright and contracts and licenses. Then to talk about our options for altering the current landscape. Because some people are not comfortable thinking about altering the current landscape, but we might have to make things work well for us and our users in the future. So things to think about for altering the current landscape with respect to contracts and licenses, copyright, and then thinking about that a little bit outside of the legal perspective with some, very briefly, some considerations of strategy and ethics. So here's my question for you, audience members. What does copyright law currently say about sharing our stuff? What do you know about this? What can we do? And in particular, where is the law clear about stuff? Because there are some places where it is, though we don't always have everybody thinking that. And I'm thinking here that you could put answers to this question in the chat because the Q&A doesn't work very well for that sort of thing. Whoops. Sorry, I stopped sharing. Didn't mean to do that, but because I realized I wasn't seeing the chat. I'm not seeing a lot of responses in the chat here. So, oh, there went one. What does copyright law currently say about sharing our stuff? And Todd, I'm not able to view the chat window while I'm sharing my screen. So could you potentially read some of those back to me? Thanks.
Let's see. Some of the terms coming in here: print disabled, machine learning. Interestingly, no idea. I'm a cataloger, which is perfectly fine.
That's awesome. Yep.
ILL, educational exemptions, right to read is the right to mine, fair use, but it's complicated.
It sounds like people are hitting really a broad range of topics, which is what I expected from the audience here.
Library exemptions, fair use, first sale, section 108.
So if any of those things don't sound familiar to you as a participant, don't worry about it because I plan to hit on many of them. But I think the key takeaway, because when I speak with libraries groups in particular, but also educators and teachers, a lot of people seem to have the impression that most of what copyright law is about is saying no, is about saying you can't do that, you can't share, you can't do this and that. So I always like to start from this frame of the law already says we can do many things in many different situations, and many of these things are actually fairly clear provisions. Fair use, as people mentioned, is complicated, although I think it's totally manageable. But there are some really clear things, and hopefully people are familiar with the idea of a public domain. So copyright law says eventually we all own things that have a copyright. Um, how long it takes changes from time to time. So the picture on this slide is a drawing that Michelangelo did of depicting Cleopatra. So that there was no copyright law when that was created. Whenever anybody says we have to have copyright law as an incentive for creation, I like to go, well, what about all the stuff people made before there was copyright law? But putting that aside, even now, when there is copyright law at the moment of creation and things have a copyright when they come into existence, there are lots of things where copyright no longer covers the works. And this is just a really brief overview of US law on this point. So unpublished works are in the public domain 70 years after the death of the author. So your shortcut for that right now is people who died prior to 1950, their unpublished works have no copyright anymore. There's also, if you don't know exactly who created them, there's still a limit. There are actually some countries in which if you don't know the creator, there is no limit. So we have a bonus here, even though this feels like a very long time, 120 years from the date of creation. If you don't know exactly when it was created, yeah, things get complicated even with the public domain. Then there's published works, which is also fairly straightforward. You may have been familiar with this idea of 1923 as sort of a magic year for copyright. As of 2019, that's changing every January 1st. So right now, anything published in the United States prior to 1926 has no copyright anymore. And things can get complicated for corporate authorship where there's not an individual associated, but there's a time limit on those. And then this is a key thing that I think a lot of people in libraries are not always aware of, although I think the University of Michigan and their copyright review management project has done some really good examples of how this is worth digging into. From 1926 to 1978, there were lots of technicalities about how copyright could end, and there are tons of mid-20th century works that have no copyrights anymore. If there's no copyright, it's not that there's no value in it, it's that it's very valuable. We all can behave as if we own it. Then there's section 108. The image on this slide is of somebody operating a photocopier wearing the mask, the helmet of a stormtrooper from Star Wars. That's not particularly on topic, except that section 108 is the set of copyright law that gives specific provisions for libraries and archives to do special things. We can do stuff that other organizations cannot. So you have to qualify for the section 108 provisions, you have to be a library or archives that are open to the public or at least to specialized researchers. So this can apply to special libraries, but you have to let some people in who are not necessarily part of your organization. One thing that I'll often point out with this is that people will often ask me, can we scan all this? So academic departments will say, well, we have this collection, can we scan everything in it? And I'll sometimes say, you could, there are these things you can think about, but an easier way to deal with it would be for you to donate it to your library along with funds for the digitization. Because your library can't scan it if they have no money, but your library can do things that your average academic department cannot, just under the existing law. So section 108 gives us the right to have unsupervised reproducing equipment in our libraries and to be limited in our liability for that. It gives us rights to make copies for patrons in a whole bunch of different situations. And as people mentioned already in the chat, this is where our interlibrary loan provisions come in. And the ILL provisions are actually fairly applicable right now for helping people with pandemic-related access requests, although they don't cover everything that everybody might want to do. And then there's a couple more parts of Section 108. You wouldn't think that preservation and replacement copies would necessarily be relevant to sharing things online, but they maybe are. So there's a lot of room in Section 108 for making copies of things in order to do preservation or to replace damaged items. There's a limitation, and I'll come back to this later, but there's a limitation that things that we make, preservation copies we make in digital formats not be distributed or made available to the public in that format outside the premises. We'll come back to that. And then there's Section 109, which has also been mentioned, and that is the one that basically says if you own a thing, if you own the physical thing, you can do stuff with it. If you own it, you can lend it. That's how libraries in the US loan books. If you own it, you can sell it to a used bookstore. And one that we sometimes downplay, Section 109 has a display provision. So if you own a painting, for example, you can put it on exhibit. You don't need special permission for public display if you own the original item. Again, one that may have some relevance for online exhibits. Then there's fair use. This is all, there's other things too, but then there's fair use, which a lot of people do think of as complicated. I sometimes frame fair use as something that people are trying to make you nervous about, for a variety of intents. But I like to say fair use is not actually too hard. I have taught kids in middle school and younger to have fairly reasonable fair use analyses. It's something where repetition helps and makes it seem less difficult. There's also a thing that lawyers do about fair use where they say fair use is just a defense to copyright infringement. And that used to be a little bit more true than it is, without getting into legal technicalities too much. What they're saying is that if you have a copyright lawsuit, you raise fair use in the defense stage. And that used to be where you raised it, but that's not true anymore. So if somebody who's a lawyer tries to tell you fair use is just a defense to copyright infringement, you can say, well, no, I mean, cases have been dismissed at summary judgment on fair use, and for a variety of other stages prior to the defense analysis. So fair use is a right in some interesting ways, but it is not just a defense to copyright infringement. And for those of you who are a little nervous about the idea of fair use, or who feel like it's a little bit unreliable, because it is very flexible, those are kind of the same thing, it's heavily used by cultural organizations. Almost every museum that you know that has large portions of collections online and smaller images of their collection items is relying on fair use to do that. It is a little complicated, but it's not as hard as people make it out to be. And then, we don't have time to go into the details, but there are some legal details of the 4 factors of fair use that many of you may be familiar with, and transformative use, which is sort of related to the 4 factors and sometimes a little bit separate from them. So that's the current copyright landscape. Current landscape as far as contracts and licenses. Well, I think we tend to think about, especially with our subscription content, contracts prohibit us from doing things. Often they prohibit us from doing things that would otherwise be allowed by law. So we can have contracts for subscription access to materials that prevent us from using them for interlibrary loan. The law says we can lend it. We sign a contract that says we can't. Happens sometimes. But here's a very useful way to think about contracts. They can also allow us to do things that the law would otherwise prohibit. So even without pushing on existing contracts, one thing that we can often do via a subscription contract. So in an academic library, we sometimes purchase video streaming rights. So we'll buy video, we'll license video content to be streamed. With a physical DVD, there's actually a statutory right to show that in class. So you don't have to pay to show your DVD in class. But if we own a physical DVD, that doesn't necessarily cover things like having a 500-person evening lecture that's not associated with a class, where we charge $5 for admission or something like that. Well, our subscriptions for video streaming often say that you can use them for any purposes, other than selling commercial access. So that's a way where the default license lets us do some stuff that we might not otherwise be able to do. So contracts, I'll come back to these as well, but they can be barriers, but they can also be things that create new space. Another example of ways that contracts create new space is Creative Commons licenses, which I love. You may notice that a lot of my background images are Creative Commons licensed images, and on this slide there's just a stack of papers photographed here. I know I can use this for non-commercial purposes because the contract that the creator placed on it, the Creative Commons license that they used, says I can. So how do we approach, if that's the current landscape, it lets us do a lot of things, but there are some limitations. How do we approach altering the current landscape? One way we can think about that is thinking about pushing the bounds of copyright and contract law, which may make some people uncomfortable, but I'll talk a little bit more in the strategy and ethics part about why there might be a room for a lot of different approaches to this kind of work. So contracts and licenses, how do you push the bounds of contracts and licenses? Well, step one is read them. I would guess that there are not too many library organizations that purchase content without reviewing the license at all. But I think there are some, especially those with limited resources. You know, my organization, the University of Minnesota, has an entire staff person who has expertise in electronic content licenses, and she has people who work with her. You know, that is a huge organizational benefit to us, and lots of organizations just don't have the resources to do that. Do you still think reading contracts, fairly baseline, important to do? Second is negotiate them. And again, this is about resource allocation, but if your organization doesn't negotiate content licenses, you are doing yourselves and your users a disservice. The University of Minnesota, as an example, again, has a list of things that we always negotiate about, some of which are deal breakers, as in, if you cannot agree to this, we cannot license your content. And among them are things like we want to preserve our right to use them for interlibrary loan. The University of Minnesota works with Minitex, actually Minitex is part of us, to do massive amounts of interlibrary loan lending across the upper Midwest. And so, you know, interlibrary loan is very important to us. Here's something that people sometimes are uncomfortable with in libraries, and it's something that personally I find a little bit difficult to understand, but quite honestly, don't buy stuff that has terrible licensing terms. We do this all the time in libraries. We buy stuff that has terrible licensing terms. We shouldn't. If we have, we should stop doing that. It's something that our organization, you know, sometimes there is no alternative. And again, with the strategy and ethics, I'll come back a little bit to this, but sometimes you really have to. You don't have the option to not acquire something. But a lot of the time you have more power than you might think. And so both walking away from contract licensing negotiations, and if you have purchased or licensed content and the partner from whom you have purchased it is not fulfilling their end of the bargain, libraries way underuse the option to not pay. If they are not fulfilling their end of the bargain, we shouldn't be paying them for it either. Lots of layers there, not going to dig further, but these are things to think about. So pushing the bounds with respect to copyright, a few things people are doing. Well, there's public online copies like museum collections. And as I mentioned before, you know, lots of museums have small copies of in copyright items in their collections up online for you to look at. They're usually relying on fair use, sometimes pieces of Section 108 and Section 109. But that's one thing where people pushed the boundaries. In fact, with respect to the public online copies for museums, probably 5-10 years ago, museums were trying to figure out what can we put online. And some of the more risk-averse people were not putting anything online. And some of the people who decided to say, you know, we think we can stake out some boundaries here. We think we can set where the expectations are, and started putting lower resolution images online. And they really did set the expectations, and now it's pretty widely accepted. Educational uses. This one's been something I've gotten lots of questions about in the pandemic times. Can you do story time online? Can we record that? Can we put that on YouTube? Lots of different pieces to that, depending on your organization. Providing books and media for classes as opposed to for the public. Those are areas where there's places in the law that you can push with respect to fair use, Section 109 and Section 110, which is the educational classroom use provision. Lots of people pushing the boundaries in the areas of non-consumptive uses, like search, as in the Google Books project, or computational analysis. This is one place where contracts are doing some interesting evolution right now. If your contract doesn't say anything about computational analysis, you might be allowed to do it. Your contract might prohibit it. Your contract might explicitly allow it. Lots of moving parts there. Controlled digital lending, which is a really hot topic right now. It relies on pushing the bounds on a whole bunch of different pieces of copyright, kind of all at once. There's a fair use piece, there's a Section 109 piece, there's a Section 108 piece, there's a couple other pieces depending on who you talk to. Some of the questions people are pushing on when they try to, establish space in copyright for some of these issues are, how high of a resolution is fair use? Their initial forays for museum copying were very low resolution copies. How high can we go in terms of online access and have it still fit within fair use? Another thing with respect to collections use is, okay, so this collection, I don't know the copyright status of every item in the collection. Can I think about copyright in the context of the collection? Is it more likely to be fair use for me to use something I don't know anything about when I can contextualize it with something where I know I have a right to use it? And that would be sort of a transformative fair use idea. Section 108 and Section 110, people are pushing the boundaries on what are our premises exactly? Is the IP range of a university possibly its premises? And since Section 110 talks about classroom, face-to-face classroom teaching, is a Zoom classroom face-to-face classroom teaching? Section 110.2 has some complications for that. So, and then a big question that lots of people are pushing on in lots of different directions is the question of, can a digital copy be shared instead of a physical one? So Section 109 says, if you own the physical item, you can hand it over to a friend. Can I hand over a digital copy of that item if I sequester the physical item away? And that's something that people are, that's pretty much one of the big questions of controlled digital lending. So wrapping up, talking about strategy very briefly. While I am a fan of the idea of pushing these boundaries in lots of different directions, there are a lot of realistic limitations on the ability of various organizations to do that. There is a lot of relationship management to be done before you start pushing the bounds on anything, because as you push, somebody's likely to push back. So, who does your library report to? To what degree is that organization or those people supportive of an idea of pushing bounds? Then there's relationships with vendors and donors. I would like to push the bounds on my contract access to such and such an item, but if I make that vendor angry, I might also lose access to something that's even more essential to my organization. So there's those kinds of things to negotiate. Donor relationships similarly. Then there's risk management as an organizational issue. Different organizations have different orientations to risk. Public status versus private status can affect that, and the history of your organization. So if you went and asked, if you went and got in trouble or poked a fire in the past, you might not have as much organizational capacity for poking another fire in the future. Or you might be, as an organization, you might say, our identity is we poke at the fires and start them up and get something done. And which leads me to the last point here, which is questions of ethics. And this is very much my personal take on this. But I think the ALA Code of Ethics is an interesting thing to look at here, because while it talks about balancing IP, it also has a clause that specifically says we don't put private interests over the interests of our users and organizations. I personally would add in another layer there of our users, our organizations, and the public in general, I think, are more important interests than those of private individuals or private companies. So I think it's ethical to push on these boundaries when our pushing is for the benefit of our users and the public. And to illustrate why I think that's really a good thing a lot of the time is these benefits to taking these risks. University of Michigan and others and Google really pushed the bounds with Google Book Search, and we get HathiTrust and the Google Book lawsuit, which ultimately basically says it is okay to scan things in order to make them full text searchable. And even more importantly, from the Hati case, we get pretty straightforward case law that says um, making things accessible is fair use, which was not as clearly established in the law prior to that case. These are huge public benefits, and they really, to my mind, make the risk that those organizations took very worth it. And I think I've hit my time limit at that. So I will stop sharing my screen. And I think it's time for questions. Do we still have time
Sure.
for that?
Oh, yeah, absolutely. We got about 10 or so minutes for
Oh,
questions.
good. That was
So if
what I was
anyone
aiming
has,
for.
yeah, if anyone has any questions, use the Q&A functionality. Um, there's a question here. I'd love to get your broad level take on the in-class or not distinction being during COVID. It seems like this is a continual sticking point on campuses right now because we do a lot of non-classroom programming where things come into play.
Yeah, that's I appreciate that question. I guess there's the lawyer response to that, and then there's sort of more the practical response to that, which is so the lawyer response is, I guess it depends a little bit on which pieces of the law you're hanging your hook on for what you're trying to do. So if it's not a course, so I don't, maybe we're talking about, oops, sorry, I switched my screen there. Maybe we're talking about playing a video, for example, playing a film, and you're playing it for your students, say, and I'll talk about a couple of different possibilities here. You're playing it for your students in a live Zoom session. Might fit into the idea of face-to-face classroom teaching. The section 110.1 provision, which for certain covers playing a video in class when you are physically in the same space as your student. Section 110.1 might apply, except that section 110.2 is about distance education. So the fact that 110.2 exists slightly undermines the claim that 110.1 covers showing things in a Zoom class session. I'm arguing both sides of the idea here. So that's if you're relying on section 110.1. But are you relying on section 110.1? Maybe you're relying on fair use. If you're relying on fair use to show a film in class, it really helps to have it be closely connected to your pedagogical goals and to be having a discussion with your students about it. It's certainly, it's better for your fair use argument if you're not sharing the entirety of a film, but especially for things that are not currently available on the market. And, what market are we talking about? The market for streaming, the market for physical access. That's very complicated right now with a lot of our traditional workarounds for, like, if there isn't online access, traditionally we put it on reserve physically and students can go watch it. We can't do that right now very effectively. So what is the appropriate not available on the market consideration for fair use? There's a lot of moving pieces here. And then there's the fully practical consideration, which is most of the instructors that I know are only slightly thinking about copyright. I'm doing my best to give them all the information that I can, but there are so many other pressures on instructors right now that I don't know how many of them are even thinking about this when they think about something like showing a film in class, because physically in person, the law is clear they can do that. Why it should occur to anyone that it's different on Zoom is not apparent to me. It is different, like the law is not clear about that, but I can't, instructors are not necessarily going to recognize that off the top of their head. And then if what you're thinking about is a non-class related university use, almost all of those moving pieces that I just outlined kick in, and then and then there's more. So an online story time would be something that's, it's not related to, this has actually come up from University of Minnesota users. Can I record myself reading a children's book for a program related to the University of Minnesota? It's not a class at the University of Minnesota, but it is educational programming from the University of Minnesota. And again, complicating that factor, there's Carrie Russell from ALA wrote a pretty great piece about how she thinks digital storytelling time falls within fair use. But early in the pandemic, lots of children's books publishers issued fairly blanket permissions to read stories online. And I think that, the very cynical part of me says that may have been in order to say that you need permission. Because if so lots of people wouldn't record things where there wasn't a blanket permission. And that sort of establishes the idea that people expect that you have to get permission. It's a little bit of a chicken or egg kind of a problem. But if they offer permission and you rely on permission, then you've sort of established that maybe permission is needed.
Yeah.
I know that was not a very direct answer or response to that question, but I hope it covered some of the relative points, Callan. I don't know. Feel free to
No,
follow up.
yeah, absolutely. I think it's none of these questions are easy or simple, and there are many overlapping areas of the law which it helps to have a lawyer on staff. Another question came in. Interested to get your thoughts on exclusive digital content on platforms like Spotify or Netflix or Amazon that do not give licensed access to libraries. Are there ways to push the bounds there?
That's that's a really big challenge for the primary user group that I support right now. In particular, Netflix. In fact, because instructors want to use Netflix content in classes, and Netflix is only available to personal subscribers. I don't have immediate, like organizational response to that. I think one of the things we can do is, as organizations, talk about the fact that people won't sell this to us. But at the same time, if this were available as an organizational license, as an institutional license, I'm not sure it would be coming with the types of affordances that we expect and need for educational access to content. Thinking about the streaming platforms that we do use as a university library, there's is it Swank that offers, I get all the vendors mixed up. There's one vendor that offers access to feature films with terms that are relevant for an academic organization. There's also a lot of smaller vendors that they offer terms that make sense for an academic use community. Yeah, Canopy, thank you. So Swank actually is somebody that's a little bit more on like better on my list. There's some issues sometimes, but those that sell products that are primarily of interest to an academic user community are aware of the needs of an academic user community. And so they have terms in their licenses that say things like, you can use these for classes. Well, we don't actually need that term because the statute already says we can do that. But you can use these for classes and you can use these for other university educational uses. And, but then even with those vendors, there's questions that I have, like, do these subscription licenses let us have our preservation statutory rights? Most of them don't. Most of them don't let us make copies. And I know for a fact that we cannot trust the film and recording industries to make archival copies of their own content, because they're frequently coming to us as libraries and archives asking for archival copies back to digitize. So I worry a lot that these licenses, the ones that are offered to us as academic institutions or as public service institutions, cover a lot of what we want to do, but not all of it. I think as far as advocacy at an organizational level, we can advocate for sensible lending, but then layering on top of all of this, one of the reasons it's hard for Netflix to sell things for public institutional uses is all of the layers of licenses underlying their use. So Netflix has limited time access to content, or, hopefully you've heard of this with the Eyes on the Prize documentary, but like a movie that only has licensing for the music for like a 20-year term, and then the music licensing for that film has ended, so they can't distribute the film anymore, even though this is again coming back to why we actually need to own physical copies. If we don't have copies in libraries, we will lose access to these things over time. So it is difficult. The more media, the more layers of media there are involved in a consumer video or audio product, the more complicated it is for them to give us a license that works for us. But we're also obviously not a user community they're particularly interested in. And you can go right back to ebook licensing direct from publishers. Publishers pretty clearly don't actually want to license ebooks to libraries, or they would be offering terms that weren't so ridiculous. So basically, my take on a lot of this is be loud and don't buy things that are crappy. But I don't know how effective any of that is.